Hello everyone, I'm George from Ireland, so welcome back to the English Law channel. So I'm going to carry on looking at cases about proprietary estoppel because there are so many cases on this one. I looked at Henry and Henry yesterday night, and Sudget, so on to other crucial cases in this matter. For example, Southburn and Blackburn 2014. So these two people, Southburn and Blackburn, they met in 2000. In 2002, they found a house that they wanted to share with Blackburn's two daughters. So Blackburn didn't have very much money. Southwell took the title of the house in his sole name and bought the purchase with the equity from his previous home and a mortgage for which he alone took responsibility. So Miss Blackburn had given up her job, and she had a rent-controlled secure tenancy of a house, and she'd spent about £15,000 on that house, like renovations and so forth. She'd also invested a further £15,000 in the new shared house with Mr. Southwell. Their relationship came to an end in 2012. Miss Blackburn applied to the court asking for an equal share of this home that she'd shared with her boyfriend. So the the county court, in the county court, her claim was for a constructive trust was rejected. The court did find in her favour when it came to proprietary estoppel, and said she had the equity of £28,500 in the house, and that would put her back in the position that she had been before she gave up that rent-controlled house to live with Mr. Southwell. So this was appealed. And then Lord Justice Tomlinson said the first instance judge's findings had been correct, and there had been an assurance that she had some equity in the house. But the couple hadn't actually discussed ownership of the house as such, but it was sufficient that when they discussed the move, Mr. Southwell had promised Miss Blackburn that she would always have a house there with him, and this was intended as a permanent thing. The Court of Appeal also said, at first instance, that the determination that Mr. Blackwell's promises were made with the intention that there could be reliance on those same promises, and Miss Blackburn had indeed relied on them to her disadvantage. So Lord Justice Tomlinson looked at the different ways that a detriment can be treated, not simply, as he said, as a narrow and technical concept. Remember what Lord Justice Walker said in Gillett and Holt. And it should be assessed and evaluated over the course of the relationship. He was citing what Lord Walker had said in Thorner and Major. Therefore, when they agreed with the first instance decision, it was obvious that a detriment to Miss Blackburn had been proven. She had given up that secure home with the low rent. She'd given up her job when she moved into that house. So that was why equity was found in her favour. So let's look at Davies and Davis, 2016. So Arian Davis had spent lots of years working on her parents' farm in Wales. She'd been away, she'd come back several times. And now her parents wanted the farm to remain in the family when they died. So Arian was the only one of the children who wished to be involved in the farm. So in 1985, Mr. Davies told her that she would inherit the farm. So she had a fractious relationship with her parents, and that's why she'd gone away several times, but they've been reconciled on several occasions. Anyway, so when she's working on the farm, she received a bed and board, but she was very poorly paid. Remember, this is an era when there was actually no minimum wage. So Arian had also turned down remunerative employment elsewhere, less demanding jobs. So when she went back in 1990, her parents vowed once again that she would join their business partnership, but they didn't sign the partnership that they drew up in 1997. So they produced the document, but there were no signatures. So in 2009, Arian was shown a draft will which said that she would inherit the farm. But then Mr. and Mrs. Davies the next year drafted a new will, and as testators, they left out that provision saying that their daughter would be the sole inheritor of the farm. By 2012, the family relationship had turned sour once again, but this time it was so terrible that Arian left forever. In 2013, she lodged a claim in proprietary estoppel saying she had an interest in the land and indeed the dairy business. So the county court decided that Arian was entitled to an equitable remedy. The question was how equity could be satisfied. It was believed that in this situation, as Mr. and Mrs. Davies were still alive, it wouldn't be apposite to transfer the farming assets, and a monetary award for £1.3 million pounds. That was the value of the business. Because that would be a fair reflection of the expectation and the detriment that Arian had undergone. But the Court of Appeal said no, that award's down to £500,000. And they said that the first incidence approach had been too wild, bearing in mind the factual set of this case, when they'd looked at the detriment and exactly what the claimant had expected. So as for the reasonable expectation, it was found that over the years there have been a number of very different expectations. Some of these expectations have been rejected, they've been really inconstant, and one later expectation had displaced an earlier one. So the proof of detriment was not enough to show that Arian had positioned her entire life on the basis of these promises. That's why she'd moved away several times. So look at Moore and Moore, 2018. Roger Moore, not the famous actor, and his son were farming in a business partnership. So Stephen Moore, that's the son, he claimed that his father had promised him, that's Roger the father, that he would inherit Roger's share in the business. But the father and son then had a terrible row. Roger was no longer a capable testator because he was senile. But the father anyway, so the father wanted to end this partnership. Stephen launched a counterclaim, and he based this on proprietary estoppel. He tried to prove the elements of the claim. The main issue here was what was the right approach to take and what remedy should be granted. So at first instance, the judge felt sure that that equity could be satisfied by ordering an instant transfer from Stephen to Roger of half a share in the business and assets, and that would effectuate Roger's unwavering intention to keep the farm within the family. So the judge believed that Roger and his wife, who was Stephen's mother, Pamela is the wife, the mother of Stephen, Pamela would continue to receive what she'd expect to receive from the farm during her lifetime. So this meant Stephen would have to provide for his parents, Roger and Pamela. They would be allowed to live in the farmhouse. He would have to pay for the cost of running the house, any care and living expenses. So this finding of estoppel was then confirmed by appeal. The Court of Appeal concurred that ordering immediate transfer of Roger's share to Stephen would be allowed. But Lord Justice Henderson said that the remedy awarded at first instance didn't recognise the partnerships partnerships, well, there'd be the assumption that the partnership would remain harmonious, but it hadn't. It become disharmonious. So therefore, it just wasn't realistic for the order to make the parties financially interdependent permanently. A better resolution to satisfy the equity in this situation would have been to split the parties apart. This would oblige Stephen to make a liberal financial donation to his parents, Roger and Pamela. So remitting the determination of the particulars of the order to the High Court, the Court of Appeal offered some counsel on exactly what remedy would be considered apposite. In return for Stephen getting his father's share, it was said that the order would oblige Stephen to do certain things. First of all, to pay a large lump sum to his radio rentals, and permitting his mother to have a new house, and covering any costs of future health needs. Secondly, he would have to be responsible for his father's health costs and pay his mother a weekly allowance. And lastly, that he would have to pay any tax liability from the order. Okay, so coming on to James and James, this is a 2018 case. So the claimant is Sam, and he worked for 35 years with his father Charles. They had a farming and hauling business. So in 1990, Sam became a partner in the business along with his father Charles and his mother Sandra. The partnership came to an end in 2009 because there was a family breakdown. So Charles gave some of the land to Karen, who was Sam's sister. So what next? Charles died in 2010. He had earlier transferred the asset into his and his wife's joint name, and he made his last will and testament in 2010, leaving his legacy to his wife and his two daughters, but not to Sam. So Sam tried to challenge this will. He also said he had a proprietary estoppel claim in relation to the farm, and this was a claim against his mother and his siblings. But these claims failed. Judge Paul Matthews threw it out because Sam couldn't show that there was unequivocal promise by his father Charles to leave the farm to the son, Sam. Charles sometimes had tried to had told his son what his testamentary intentions were. However, the judge said that the statement of current intentions as to future behaviour is not a promise of that behaviour, nor does anyone intend others to act on it. So these claims were not successful because it was so unclear, so ambiguous, so shifting, like Shaw and Shaw 2018 and McDonald and Rose 2019. The situation of the parties' characters was crucial in the judge finding the statements that Sam had made to Charles had made to Sam about one day inheriting the farm were not promises. So Charles was someone who was loath to commit himself to anything, and Sam was known to be very eager to get his hands on the property. The judge also found that he was fully paid for his work, and he had been benefited from it, even though he hadn't been a partner. So Judge Matthews said that Sam hadn't relied on this, certainly not to his detriment, and even if he had been given no inkling that he was going to inherit the farm, he would still have behaved the same way. He had not thought about going away to do a different job. Judge Matthews said that even though Sam had worked diligently the haulage business, he had not worked well on the farm because he didn't care about it so much. So in the last analysis, the case has got some valuable obiter dicta remarks about how proportionality relates to the level of detriment suffered and to the remedy that's awarded. So it's a bit similar to Davies and Davies, or indeed Sudgett and Sudgett. So this says it really should be the expectation measure that's granted, not something more. So Wills and Sowry is another leading case on this one, which dates to only 2020. So this one is strange in that it's an estoppel-based claim to a farm where the claimants are not member of the dead person's family. They were brothers James and Matthew, and they both made different claims about their dealings with their long-term friend Tony. Tony owned Guildmore Farm, and he had various buildings and barns, and the value of this was £600,000. Tony was divorced. He had a daughter, Claire, and he had fallen out with Claire totally when she was 22. So Tony died not having made a will. As he was intestate, Claire inherited the lot. Matthew then made a proprietary estoppel claim about 50 acres of farmland and the outbuildings, though not the home. The High Court accepted this more than once. More than once, Tony had promised Matthew the farm was his. In 2005, Tony had been reconciled with his daughter Claire. Matthew realised that Tony would leave the house to his daughter, Claire. So it was accepted that the two men were very close friends, and it was almost a father-son relationship. Matthew implicitly trusted Tony would honour his promise. Matthew worked at the farm for over 20 years. He did all sorts of work, and this was regarded as being to his detriment. So equity had arisen in Matthew's favour. The court said that it would be proportionate and right to remedy Matthew's expectations was for Claire to transfer all the land, except for the plot that James was claiming, to Matthew. And there's more. So, so the outbuildings would go to Matthew. James made a separate claim, and this was for a small area of farmland, worth about £30,000, where he built a log cabin, and that was intended to be a family home. So there was an oral transaction in 2012 where Tony had promised to leave James his land at his will in return for James giving him a Jeep, which James did. The judge said that James had satisfied all the requirements of estoppel, and the fact there was no written contract in compliance with Section 2 of the Law Property Miscellaneous Provisions Act 1989 was immaterial. So James succeeded in claiming a proprietary estoppel. So there's still a lively debate about the relationship between formalities and proprietary estoppel. The judge found that it could, despite Lord Scott's obiter dicta judgment in Common Yeoman's Row, that they didn't need such formalities. Anyway, if you look at Section 2 of that Law Property Miscellaneous Provisions Act, it said that an agreement can be a valid contract, but it doesn't stop it being an ingredient in another course of action. The lack of formalities might mean it's not a valid contract, but it can still be valid in another type of action. Therefore, a separate action based on proprietary estoppel need not be seen as defeating Section 2's policy, about the requirement for formalities. Lord Justice Kitchen made similar remarks in Farrer and Miller, 2018. Okay, so that's enough at the moment. Toodaloo.